All right, everyone good to go? Morning, afternoon, thank you everyone for attending. Anyone that is joining virtually, I have everyone muted. I will open it up for questions towards the end, so please keep yourself muted while we're conducting the presentation. With us, we have Nancy Harrison, who has so generously volunteered her time to speak on some family law matters. So I'm going to turn it over to her, and thank you again for joining us.
Okay, thank you. I'm going to give you a little background about myself because I started in the legal world years ago as a paralegal. And I worked for 8 years for attorneys in Georgia. And I figured out that I was doing all their work and I wasn't getting paid. The only thing I wasn't doing was depositions and going to trial. So I went back to school and finished my undergrad and then went to law school. So I chose family law, I think, in part because I was adopted as a child. I was really interested in helping domestic violence victims in Georgia. And so when I got into law school, I was like, this is me. This is where I should be. So I do love it. My boyfriend is an attorney. He thinks I'm crazy. He would never handle family law cases, but I do enjoy it. And I worry about some things when I go home at night, especially children and situations, but I do sleep at night. So I do my job during the day and worry about people in the daytime most of the time. I am going to pass around a sign-in sheet just because if anybody has any particular questions about their type of case. Yeah. I know, I'm just scared too. So I can learn a little bit about you, maybe not for today, but another day. I believe you're recording these.
Yes, and if anyone that is joining us virtually has a question, please put it in the chat and we will circle back to it. We're going to check it periodically.
Okay.
And yes, it's being recorded.
Right, and because today is the first day, I'm kind of going to give you a general overview. If somebody came into my office for a consult, I would give them this information about a case, any type of case. So I want to start with the dissolution of marriage. Well, let me start with this. Our clerk's office here is here to give you paperwork that you can fill out. They can tell you where to put things. They cannot give you legal advice. They cannot tell you this is what I think you should do. So on that note, an attorney is really the only person that can give you legal advice. And I'm going to say today, I don't represent any of you. I'm going to give you some information about the court system and how cases are handled, but I can't really give specific legal advice about your case unless I have all the facts. Because facts, family law cases are fact-driven. They really are. But we will talk about hearings and if you're representing yourself, some of the things you need to know before you go. So there are some sheets over here that if you want to pick one up, these come from the St. Johns County Legal Aid Office where I also volunteer. And it gives you some information. There is a workshop, if you will, once a month. You can bring in your forms and an attorney will go over them with you and make sure you have everything in place. Make copies of things so you can bring them to the clerk's office. Keep one for yourself, file them, originals, and then you'll have a copy to send off to be served as well. So we do help with that. From time to time, they will see a situation that comes in the door that potentially needs an attorney. And so there are a few attorneys that will do some pro bono work if their calendar allows for it. And there's also, thank you, there's also some information on the back about some attorneys who will help you for a flat fee of $75. Okay, so you might want to pick this up if you think you might need some help along the way. So you can also get information from flcourts.org. They have all the Supreme Court forms, which are going to be the same forms that the clerk gives you here. They have instructions for all those forms. Those instructions will tell you what other forms you need to file with the form you're filing. So it really does give you a lot of information. Are they confusing? They can be very confusing, okay? I mean, that's just life. And the legal system's not easy. It's not. So I try with my own clients, I try not to talk in legalese. I prefer to just tell you, like we're regular people, because I am a regular person and I want people to understand. So if you have a question about something I'm saying today, please let me know. You can also go, like I said, this pro se clinic. The St. John's Legal Aid Office also has a pro bono clinic where they help with going through issues in a civil case. And the Florida Bar also has a lawyer referral service you can call if you want to talk to an attorney. So first of all, do you need an attorney? You don't have to have an attorney, but I would always recommend that you at least talk to one at some point, either before, even in the middle. If you get stuck with something, call someone, pay for a consult and find out where you're at and get some legal advice. Because the judge can't give you that and the clerks can't give you that. And all your neighbors and your friends who've been in the same situation, it's not the same. Your case is just not going to be the same, okay? So I understand people getting advice from friends. I get my advice from my friends too on certain things, but be careful with that. That can be very dangerous. So in a dissolution of marriage, which is a divorce, ironically, if a court were to have a trial on that type of case, the court goes through the acronym PEACE. P stands for parenting issues. So that's parental responsibility and time sharing. Parental responsibility is decision-making authority, and it's almost always shared. It would be an extreme circumstance that a judge will give someone sole parental responsibility. And the court does this in this order, and I'll explain that when we get down towards the end. So the E is equitable distribution. In a marriage, anything that's acquired from the date of your marriage until the date that you file your petition is marital, assets, and debts. So let's say someone had a student loan before they got married, that's theirs. That will forever be theirs. It's a non-marital asset. It won't end up in your scheme of equitable distribution. A court is going to try and make that as equal as possible. But if you're in a case, in any family law case, you're going to be mandated to mediation at some point. So people can come to an agreement like they decide. It doesn't have to be equal. A lot of people say, I'll take my own debt, I want my car. If they have a house, let's sell it, we'll split those proceeds. And maybe it's not equal, but it's a way to resolve your case. Okay. A is for alimony. Now, alimony is always based on one party's need for it and the other party's ability to pay it. And I'll talk about some of the discovery, but a financial affidavit in a family law case is very important. And the more accurate it is, it's perfect, because the judge can look at that and see what your income is, see what expenses you have, see if you're in the hole every month, if you have extra money at the end of the month. And then the assets and debt section of that really should lay out for the court all the assets, marital, non-marital, all the debts, same thing. So really it's a great snapshot for a judge. And then alimony now is quite different than it was. And so there's a statutory formula. It's very much like child support. You basically plug some numbers into, we all use the same program, and it spits out a number and it spits out how long the alimony could go on, because there's no longer a permanent alimony, so it won't go on forever. Then the C is child support. This is also statutory, and those numbers come from both parties' income, daycare expenses for a child because of work, health insurance for a parent, each of the parents, and then health insurance for the children. And then the number of overnights. So here is where we start. The P, you need to know the number of overnights. If there's any income that come out of an asset you have, that's income. So it's included for the purpose of alimony and child support. If you're gonna get alimony, it's income. So we're building down to this child support number. Now we have your income and we have all that information. Again, we plug it in, and the judges do too. They have their own programs. Plug it in, it spits out a number. That's what it is. The court can deviate, but there are some factors you'd have to get some information about that as to whether the court would deviate from that. And then the last E is everything else. It's usually attorney's fees, which is also based on need and ability to pay. It could be a dissipation, which means you've spent money in the last few years of your marriage on something that you should have, that benefited yourself. This could be drugs and alcohol, it could be gambling, it could be an affair that you've spent money on. That's part of your equitable distribution. You're entitled to get half that money back. Okay. Or lose half if you're the party participating in that. So I talked a little bit about how long your marriage is. That's from the date of filing, from the date of marriage to the date of filing. In St. Johns County and every county that I'm aware of, all parents, not just in dissolution cases, but in maternity cases as well, have to take a parenting class. You have to, it's mandated. Everyone in a family law case is going to get a standing family law court order. And in the 7th Judicial Circuit, it requires that you have that parenting class taken. In St. Johns County, there's also, and you read these, the clerk will give you one, read it. It is a court order. If you violate it, you could be held in contempt at some point. And our judges here will ask you if you've read it, if you've done something. Did you read it? So make sure you read it. Most of it deals with children, but you need to be aware that it's out there. And in St. Johns County, there will be a case management conference set up in every family law case where you have to go to the court periodically and just kind of check in. Have you got your discovery done? Are you ready for a trial? Do you need mediation now? Just to check in and see where you're at. And those are important and they're mandatory. You have to show up. If you don't show up, the court can dismiss the case, which you don't want. If you've worked really hard to get to that point, you don't want it dismissed. In family law cases, this is a dissolution or a paternity action. There is something called mandatory disclosure. These are documents that will back up that financial affidavit I was talking about before. The financial affidavit is number 1 in that mandatory list, and everything else follows. So your income, you need pay stubs, you need tax returns. As far as your expenses, things that you have debts for, credit card statements, those kind of things, you have to produce those. And then there's some miscellaneous things like if you have something that shows something is non-marital, like a 401k or something you had beforehand, you need to go back to the date of marriage and see if you can get that statement. That's the only way you're going to be able to prove it was non-marital. Okay. So those things are mandatory. We do not file those documents with the court. They are just served on the other person. You do file your financial affidavit. There is a new rule now that you don't necessarily have to file your financial affidavit if you agree, but there needs to be something in writing that you're not filing that document. Because those are public records. Someone can go in and pull them if they want. So if you don't want to do that, if the other party agrees, you don't have to. All right, let's see. People often ask, I have 3 children. We had a child before we got married, but, it's my husband's child or my wife's child, obviously it'd be the wife's child. So, is that child part of your marriage? It is. If you have a child and then you get married, that child is of your marriage. So if you adopt a child during the marriage, really important thing is after a separation, if someone gets pregnant, you need to let the court know, especially if it's not the husband's child. That's important because you may stick someone with a child, taking care of a child forever that doesn't belong to them. And your husband may agree, you know, I'll take care of the child, but you need to let the court know, because they need to address that issue. All right, and then, paternity cases. I'm gonna start with Department of Revenue child support issue. So if you get some kind of state assistance, and it could be Medicaid for your child, food stamps, any kind of help you get from the state, and you have a child, they're gonna want somebody paying child support. So they may step in, and it's not a marriage, if it's just a paternity situation, they'll serve the other party and establish paternity so that we know this is the child of this relationship. And that could be, somebody can voluntarily say, yes, that's my child, or they'll get a DNA test. The Department of Revenue can only establish child support, period. They can't provide anyone with timeshare. So if you get a letter from the Department of Revenue, read it. They are very time sensitive. They have deadlines in them. And if you don't meet them, the Department of Revenue's administrative system can set a child support number, and you are just going to get something in the mail, potentially an income withholding order, and they're going to start taking the money from you. So you have to pay attention to those things. If Department of Revenue gets involved and you don't want to deal with the Department of Revenue's administrative system, you can file a petition in the circuit court and ask the judge to deal with it. Now, if you do that, you can I would go ahead and file a paternity action and get time sharing. Get time sharing set up, get child support set up, take care of everything, or else at some point, somebody's gonna go back to court, I won't time share. Why not get it? Now, that's on you. If you don't want the other person to have time sharing, maybe you wanna go through the Department of Revenue, or just limit it to child support, but that's up to you. Let's see. So going back to the paternity case, this would be necessary. Let's say there isn't a Department of Revenue. You're not getting child support. You want to establish that a certain person is the parent of a child. You would file a paternity action, and that would be to establish child support. One, you can request what you want in those forms. So maybe you just want to deal with child support. But that doesn't mean that the other side can't file a counter petition and ask for that time sharing. So you can file the paternity action, establish parentage, you can get child support, you can set up a time sharing plan, a parenting plan, and decide on the parental responsibility. If you have an attorney, you can ask for attorney's fees. Okay. And so when you look at those forms, be very careful, read them very carefully, mark the right boxes. If you don't ask for relief that you want in that petition, you cannot get it. So if you don't ask for it, you're not gonna get it unless the other side consents during a hearing, which I can tell you, if they have an attorney, they're not gonna consent. It just is not gonna happen. If you need to enforce child support, you can come back to the court. If you're involved with the Department of Revenue, they can do it themselves. They do track those things. I'm not saying they're very good at it, but they do track it. You know, I hear people sometimes, well, he owes $10,000 in child support. You know, if Department of Revenue is involved, he probably doesn't have a driver's license anymore. They can take away someone's professional license. So if an attorney was that far behind, they could go to the bar and suspend their license until they get those things dealt with. So you can't file contempt motions and enforcement for child support, and the Department of Revenue can do it for you, or if you're acting as a private party, you can do that yourself. So people think that I'm filing this, I'm gonna have this person go to jail. That's not necessarily true. When you go to a child support hearing, you essentially have to say, Your Honor, there's a court order, they're supposed to pay child support. That's your burden. Easy, there's a court order. He didn't pay it. Usually you can go to the domestic depository, they can print out what's been paid and what's owed. That's easy to prove. They didn't pay it. Now, does that person have the ability to pay it? Maybe they're not working, whatever the scenario is. If they don't have the ability to pay it, the court can set a purge amount, but they can't put them in jail. They just can't. If they have the ability to pay and they've just said, I'm not gonna pay you, and you can prove that, then the court can set a purge amount, and if they don't pay it in a certain amount of time, they can go to jail for a period of time. But that individual can also get an attorney for free, because it is essentially at that point, you lose your rights going to jail. So just know that. You can get modifications of your judgments other than equitable distribution. It's never modifiable. Once it's in place, that's it, it's done. Child support you can modify alimony, you can modify time sharing and parenting plans, you can modify parental responsibility. When you try any case, when you are trying to get a case started, you're thinking about it, I want a divorce. I tell my clients, keep everything. Don't delete your text messages. Screenshot social media things that are inappropriate. Save voicemails. Because when you get to court, if you have to have a hearing or a trial, it is basically a he said, she said. So the court has to choose who do they believe, who's more credible, unless you can support those things you said. So, that evidence could be documents like bank statements, those kind of things, tax returns for income, pay stubs. But there's also videos, there's photographs, there's your text messages, those are writings, essentially text messages. You can have witnesses that can testify. They've seen something, they've heard something. But you need those things with you when you go to a hearing. And you don't need one copy. You need 3 copies. You need one for yourself, you need one for the court, and you need one for the opposing party. And you should always take that, because the judge could say if you don't bring enough copies that you can't have it entered into evidence. And that is not fun when you get there and you've gotten that far and you don't have enough, and that's, a technicality, you end up in that situation. Domestic violence injunctions. Should let her talk about it. So the clerk's office has an advocate, or you can go to the Betty Griffin House. Someone will help you fill out those forms. They really, truly will help you. They will help you make sure that you put everything in it. I always tell my clients if they're doing it, and I typically don't fill those out. I send clients to the courthouse. It's free. There's no filing fee. Include every single time there's been an incident. I don't care if it was 5 years ago, coming up to present. Because this is the pattern behavior, then the court needs to be aware of that. Because what happens with that injunction is, as soon as it's taken from you, completed, filed with the clerk, it goes to the judge's desk. They read them, and if they think, based on just your writing, that there warrants an injunction right away, they will enter a temporary injunction. And they will have it served on the respondent, who is the person you're filing against. And once that person's served, it's usually immediately no contact. It could be that they're kicked out of a home where they live with someone, the petitioner. You can put in addresses. So if you have children and you don't want that person around the child for whatever reason, include their schools, include where you work. Everything, a daycare. You want the court to know that potentially this person could get to you or your children at these locations. And initially, if they're going to enter a temporary order, they're probably going to give you all of them. Okay. Then the court will set a hearing. It's usually within 15 days. The statute requires that. If you come to that hearing and the other person has not been served, they're not gonna have a hearing. They're gonna continue it, but they will extend your temporary injunction until that person is served. So the court, when they get those injunctions, could do three things. They could enter a temporary injunction and give you a court date. They can deny it, totally. Not enough, never will be enough, you're done. Doesn't mean you can't refile, but for this, what you put in writing is not enough. Or they can deny it and give you a hearing. Maybe it's enough. So, and I'm sure Betty Griffin would tell you that, if you're in that scenario, you need a safety plan. Okay, that means where's all my stuff at? I need to get up and get out of here and go hide. If it's severe, you need a safety plan. Get your kids out, leave. And that's tough sometimes, but you have to do it and get to the courthouse as soon as possible to do that. Okay. Now, I know when we were setting this up, the clerks had told me about a couple issues that had come up that they had been asked about, which again, they can't really give you legal advice. So one of them is, what if a parent is using drugs, abusing drugs? How do you prove that? Well, it's a hard thing to prove, but you can ask the court for a drug test. The problem with that is they get notice. And there's ways to clean out your system. So, if you know someone, here's where some of your witnesses will come into play. Do you know someone who knows that person and knows they're selling drugs? Or maybe you've seen it yourself.
Me?
Maybe it's happened in your house while you were living together. Those things are evidence. So you can use all of that, but not easy. I can tell you that. It's not an easy thing to prove. Then someone asked about parental alienation. Do you know what that is? Do y'all know what that is? Okay, so a parent who is an alienator is essentially teaching the children to basically hate the other parent. And the judges probably 15 years ago were not very familiar with it. And it was thrown out there as a term. It was something psychologists weren't dealing with. They didn't use that term in diagnosing people who had this type of disorder. And it's not truly a disorder, but had this type of behavior. But judges now, their judges' colleges are teaching them more about parental alienation. So a lot of them will pick up on it. Just looking at writings, looking at, how the time sharing's going, a parent's not letting another parent talk to a child. I mean, they're putting bars up between a parent and a child. And it is technically child abuse. And it has long-term effects. And it's scary, it's really scary.
Could you talk about emergency pickup order?
I can, yeah. So also very hard to prove. I mean, very hard to prove. So I have had clients who are in that situation. They go to pick up their children. There's this big ordeal with the other parent telling the kids, your mommy's making you go somewhere, with her, you gotta go to her house. When he's, coached them inside to not wanna go. So I hate to do it, but in that scenario, it ended up being an 8-day trial. This is how bad it was. The DCF was involved and CPT was involved. I had her take videos of it. He was standing there screaming, cussing her, calling her names. The kids are standing there. They didn't understand what was going on. It was horrible, horrible. And all those children are adults now, and one of them still does not have a relationship with my client. She got the other two back. The fortunate thing is, a lot of times as children get older, they do realize something was not right, and they may end up not liking the parent who started all this and really build a relationship with the other one. So I want to talk about two things: emergency motions. So a lot of people think, I have this situation, it's an emergency. in your head, it probably is in a family law case, except for the court has very narrow issues it can address as an emergency. So we've had judges tell us, if you're gonna file an emergency motion and it's truly an emergency, you better be available, you better be ready by phone to get to the courthouse or be via Zoom that day. Because if that's important, you better be ready for an emergency motion in family law. I'm gonna put this in the best layman terms I can. Means that there's blood and guts. The kids are bleeding, there's something serious going on. Or that a parent is about to leave the state with a child. Those are emergencies. Now, what the court could do, if you filed one, they can deny it as an emergency, but try and get you an expedited hearing. In fact, when I file motions like that, I ask for that in the alternative. If I'm teetering on the edge of emergency, or in the alternative, we set an expedited hearing. And if the court thinks it's serious enough, they will try and squeeze you in. That's hard for judges to do because their dockets are full, terribly full. We also had the situation with an emergency pickup order. I've only done a couple of them over the years. But let's say a parent, in the middle of the night gets up and takes the child somewhere. The thing is do you know where that child is, which is important. Because otherwise you can't really get a pickup order. So you would file, and that would typically be an emergency. Sometimes even what's called an ex parte emergency motion, which means you're not gonna give the other side even notice. So you're telling the court, I'm filing this ex parte. The other side's not getting notice, that's how severe this is. And I tell them what happened in your motion and what you want. And so in that scenario, you'd want a pickup order. So what the court would do is enter a pickup order and it would go to whatever sheriff, if it's in Florida, that county, another state, will go to that sheriff and their county or police department, because they're all different. And they go pick the child up. Okay, bring them back. A lot of times they want you there.
I have a question. Could you give us an example of something that would be an emergency pickup order and something that wouldn't be an emergency pickup order?
Well, if they've taken a child out of state, that's an emergency.
But if you have a
already.
parenting plan.
Oh, now I'm typically talking about before a case is really getting started. So if you have a parenting plan, most of the time, unless there's an extreme circumstance, both parents can leave the state with the child, potentially can leave the country with the child. Parenting plans do put in timelines, so if you're going out of state, you need to tell the other parent within 3 or 4 days that you're going, and where you're going, and where you're staying, and what phone numbers you'll be available at. In some cases, you have to tell them who you're going to see. Just, these are fact-based again, so some people put those in their parenting plans. So if you, yeah.
I got a really good example.
Okay.
We had a woman call us the other day. The husband had been gone a year. He'd been deployed in the Navy.
Mm-hmm.
He comes back and he and his girlfriend come and want to pick up the 3-year-old son. The wife said, okay. So they went, and then he calls her in 2 or 3 days and said, you'll have to take me to court to get the child back. And in that instance, I advised her to come and file an emergency motion to pick up the child, because the child was tender age. Yes, he knew that was his father, but still he would not bring him back. And
Right.
he told her over the phone, you'll have to go take me to court to get the child back. So I think that would be an emergency situation that the judge would probably enter an ex parte order and have the sheriff go and get it. The only wrinkle was she did not know where the husband was. He would not tell her where he was. He was a highway patrolman for Florida, and she could not get the highway patrol to divulge his address.
Wow. That's interesting.
Thick blue line.
Yeah, that's scary.
So we started brainstorming ways for her to somehow find this man through relatives, friends, the girlfriend, whatever.
Yeah, my paralegals good at stalking people. She can find anything. She can get some dirt on
We have a
somebody.
Gen Z on our staff that's
Yeah.
good at it too.
I love that, because I don't have time to search somebody's Facebook page, but. All right, and the last thing I want to tell you about is if you get a ruling from a judge that you don't like, maybe you don't think it's fair, And that happens. I understand that. I mean, I get rulings I don't like, and I'm an attorney. You can file an appeal. You could file a motion for rehearing first in this court and see if the judge will, change their opinion, have a hearing, explain your situation. But you really have to have a legal basis for that. And I don't like your ruling, it's probably not it. But there is an appeal process as well. If you're representing yourself and you want to file an appeal, you can do that. It gives you an option at the end of a case where you're not happy with the ruling and you can seek help. Now, I will tell you, and I probably shouldn't say this about judges in general, but if you file a motion for a rehearing, unless it's really clearly error in the law, they're not gonna undo their own ruling, more likely than not. So an appellate court is the appropriate place to go for that, because they will look at it, depending on what type of appeal it is. They can look at the whole situation, or they can look, as to whether the judgment is wrong on the face of it. Is there an error committed, which happens sometimes with child support? Maybe they just used the wrong calculation. They used gross income instead of net income in deciding those things. So, I hear people all the time complain about an end result. That's something to think about. It's something to look at. If you are representing yourself, the court expects you to know the rules of evidence and the rules of procedure, which is hard. I understand that. I mean, I have a book in my office. If I want to go read a rule and the specifics about it, then I can do that. So, but you can go to the Florida Bar website and all the rules are there. I think they even have the evidence code on there. Or you can go, you can search it. I mean, today you can find anything, Google, and it'll give you information. I think that's all I have.
Yeah, so I would like to open it up for questions.
Okay.
For anyone that is tuning in virtually, I'm going to ask that you use the raise your hand icon at the top of the box, and we can call on you, and you will have to unmute yourself. I cannot do that for you. Just keep that in mind. Once we call on you, please unmute yourself to speak. So I guess we can start by opening it up to anyone that might have any questions. In here,
Do you have
virtually?
any questions, anybody? Yeah.
Is the child support up till 18, or does it ever go past, like when they're in college?
It can go past, so it's up to an age of majority unless a child is going to graduate within that next year and is working in a good faith attempt to graduate. I mean, you're not gonna pay child support for a child, if they're 21 and they're just graduating high school. So typically it's a max out at 19. Now, if you have a child with a disability who's gonna be dependent on their parents, yes. But you need the court to reserve on that issue early on and always come back before they're 18 and not 6 months at a year. You're gonna know a year before they're 18 that they're gonna be dependent forever. So then, yes, you can go back to the court and get it extended. Okay. Any other questions? Okay, what's your question?
All right.
You can't ask me about domestic.
I can ask. Okay, so we all know that the new alimony laws have gone into effect, or most of us know that the new alimony laws have gone into effect, and also the new custody or time sharing parameters where we're automatically defaulting to a 50-50 custody. And I understand, via my sister, that that one cannot encourage any kind of prenup that involves any kind of future custody, because you cannot prenup a child.
Right.
Can you prenup your unpaid labor?
Unpaid labor.
Let's say I'm staying home, I'm having babies, alimony's not going away. How do I protect myself? I no longer have a
You
career.
could do that because that's not a best interest of the children ruling. A court has to know.
Right,
That's why you can't deal with children's issues
Right.
in a prenup. You can deal with it, but the judge is gonna throw it out.
right, the children's issues, but I'm saying the prenup as far as
Sure you can.
Any kind of so it's contractual, as long as it does not deal with the living being, it's contractual both ways, correct?
Yes.
So a person that might want a prenup because he's afraid that the gold digger would be after his 2002 Honda
Right.
also could be in retribution, given a prenup for her time, her years of free labor
Right.
that she's putting into that by providing child
dollar
care,
amount,
house
right.
care, and get a dollar amount.
I would put a
That's what I
dollar
wanted to
amount in there because
Interesting.
then when you get down the road and you're getting a divorce, well, what is that worth?
Right.
$10 a day?
And to not say that like legal advice would be just like, I wonder if you asked.
Right. Yeah, I mean, you can contract anything as long as it's legal
And
and a prenup or even a postnuptial agreement after you're married. You can't deal with like child support
Mhm.
and you can't deal with
Right.
adoption. You could put it in there, but it's.
But
not
time sharing
gonna
child
be-
support's not gonna happen.
Unless the court agrees, yes, this would be in the child's
But-
best interest for time sharing.
But any kind of, but a reciprocal prenup.
Yeah, I mean, quite honestly, most prenups are reciprocal.
Gotcha.
Okay.
Perfect.
They're protecting, someone usually gets it, but then
Mhm.
the other side has a right to negotiate their own thing.
Excellent.
But definitely set up a dollar amount for that because, yeah, somebody's gonna argue that's worth $10 a day, which we know it's not.
Right.
And let me say something about the time sharing. Yes, there is now a presumption that 50-50 time sharing is the best route to go, and that's in a child's best interest, but you can rebut that. So if you have this substance abuse issue, or you have parental alienation, maybe that's not the way a court should do it, because it does have to be in a child's best interest. So, just so you know, that is out there, and most of the time it's gonna be 50-50, but there are circumstances where you can rebut.
I have a question.
Yeah,
With the welfare of the children in mind, what are some examples of extraneous circumstances under which full custody would be granted to one parent?
yeah,
Yeah.
you know, substance abuse can be that, if it's long-term. I mean, I've had a case where someone was an alcoholic, and even during the proceedings, he had been in rehab 3 or 4 times. He had a DUI, 2 or 3 of them, so he had to blow, you know, when he's in his car to crank it up. He had driven drunk with the kids before. I mean, these things would put someone in that scenario where if they have time sharing at all, it should be supervised.
So it would be based on certain interactions of that individual with.
Dangerous behaviors toward a child.
So
Yeah.
if they've been Baker acted a couple of times, if they've been in behavioral rehabilitation programs, if they've been treated, or
So it'd have to be that extreme?
A
it
lot-
has to be
You
something.
said before that a lot of that stuff is hard to prove.
It is hard to
And
prove.
so she's giving you lots of extreme examples that are provable, and so
Yes,
that's the
They
problem.
are.
The burden of proof is very difficult.
It is.
Very difficult.
You have to
What
show
about
detriment to the children.
Statements from children or?
See, and that's hearsay. It depends on how old the child is. You might could get a judge to listen to them. If DCF has ever been involved, and CPS, CPT, and they've interviewed a child and the child disclosed something, those are things you can get into evidence. Those people are witnesses. You can get court orders for those interviews. They're videotaped. You can call caseworkers. You can call CPT people to come in. They have their own physician there. I'm just saying, there are a lot of things that seem really hard to prove, and sometimes this is where you end up in that situation and you need help. Where do I prove this? Go see an attorney. You know, there are attorneys out there who don't charge for a consult. Get some information, or, you know, go over to St. Johns County Legal Aid. Pay someone $75 to give you some advice. It's beneficial, it really is.
If the substance or alcohol abuse is documented in a medical record, is that presentable?
It is. Now, you can't use the records themselves unless you have what's called a records custodian affidavit, because I could create some kind of record and bring it to court and say it is what it is, and it's not really. So the records custodian just says, these are the documents, they are what they are, we keep them in the regular course of business. And then you could get them in that way. The best way to do that is to call a witness, call a doctor, call a nurse in there, call their records custodian, who can say, yes, that is exactly what this says.
Does it have to be subpoenaed to get access to their records or?
You, unless they're your own records, yes, you probably would have to subpoena them, and there is a process for that. I don't think that's a form. So you may need to call someone at St. Johns County Legal Aid. They could create a form for you. I'm sure somebody has one that they could send you that you could fill out yourself. Okay, but yes, I mean, anything you need to subpoena like that, you can.
There's a question here.
Yeah.
What about a substance abuse evaluation?
Yes, so there are quite a few evaluations a court can do. Just be aware these cost money. So you can file a motion for a substance abuse evaluation and have a court hear it, unless the other party agrees. Again, when you're asking for something like that, make sure you put in there you want the other side, if you want them to, pay for it themselves. But yes, you can do that. And I would suggest if you're doing that, do a little research. Find out who does that around here. So when you go to the hearing, you should tell the court who you want to do it. You know, get some opinions about people.
Also to that, I would make sure that you make sure that the substance abuse evaluation specifically is not self-reported.
Yes.
Because what will happen is that they will order a substance abuse evaluation and somebody will go in and self-report their own substance abuse.
Right.
Which is notoriously
Yes.
accurate.
Yeah, right.
I always tell my doctors the truth.
That is very true. She's right. And I've seen some of them. So they basically have a checklist. You just hand it to someone and they go, oh, you're good. You don't want that.
And that's not legal advice. I'm not an attorney. I can't give legal advice.
Right.
Third-degree felony.
Yeah.
That's just really.
There are other things in family law cases. You can get a social investigation where an individual who's qualified to do that, could be a psychologist, some attorneys do it, where they essentially talk to both parents. They talk to the children. They watch the parent with the children. They watch the other parent with the children. And then they go through the statutory factors. If it's a psychologist, they may do some psychological testing. And they walk through the factors and they basically make a recommendation about what the time sharing should be and what the parental responsibility, may be. Again, if you're filing a motion like that, ask for everything under the sun. And if you want the other side to pay for it, you need to put that in there. Or else the court. Well, it's a range. I mean, you may pay $1,000 to $20,000, depending if you get a psychologist. And what they have to read, do you remember, you're giving them evidence as well. So you send them a stack of Facebook posts that you printed out, they charge you to read all that. Now, if you're charging a flat fee, a lot of attorneys do it for a flat fee, and they won't charge you out, but the psychologist will. I've seen some.
How much notice would the other party receive if you request a social investigation?
It's a motion you would file, so they're gonna be served with it. And then you'd have to set a hearing. So everybody's gonna, unless they agree, everybody's gonna end up in front of the judge with the person making the argument why you need it. Now, the statute essentially says if there's an issue with parenting and time sharing, the court should get them one. Yes, Carol.
One case that we see consistently in the legal aid office is the case where someone is taking care of their grandson or their granddaughter. The parent is either incarcerated or they are suffering with substance abuse issues. In these instances where you have an absent parent, the grandmother needs temporary relative custody, or what we call temporary custody by extended family.
Right.
These are pro se filings that are very common, but the main thing that you need to remember is they can sometimes get consent from that parent, so that parent doesn't have to be served. But if there is no consent, they're going to object to their grandmother or grandfather having that custody. then you need to know where the address is of that person. Sometimes they are couch surfing, but you need an address where somebody can be served, or the sheriff can leave the pleadings with someone over the age of 18, and you know that it is going to make it into the hands of the mother or the father. And then we have those people who've been served with those motions, and they also come for representation.
And you said all that, but there's two parents typically.
You gotta have
So
both
where,
parents.
you've got one incarcerated, where's the other one?
The other one is, as I say, maybe suffering
Yeah.
substance abuse. Sometimes there are parents who just go off and stay gone.
Right,
But
but both parents would have to be served with that,
They have to be served,
most of those two.
yes.
But yeah, I mean, they can consent. Grandparents typically don't have rights in Florida, so I can't, sue my son's mother and my son to just see my grandchild. But in that scenario, that can happen.
I have one more question. How are patterns of abandonment viewed, and what are ways to prove that?
What do you mean patterns of abandonment? Abandonment means you just have walked away, you haven't seen your child. I mean, that's pretty easy to prove if they're just not there.
It means that they haven't given them any financial support, they haven't maintained a personal relationship with them, they haven't come to see them. So,
Or they haven't even inquired about them.
but
I've
they
had
haven't
cases like
even
that.
called them.
Is there like a time period that's?
It can be 6 months. The longer, the better. If you're looking, are you talking about terminating someone's rights?
Yeah.
So the longer the better. I mean, that sounds horrible for a child, but sometimes it's a good thing that person's not in their life if that's how they feel about the child. And anything else you can come up with that's bad about that person, that parent, will benefit you as well. And again, you've got to put this all in your documents and what you want. The more you put, sometimes it's better to put more in than too little.
We have a question.
Yeah.
What kind of evidence would matter to a judge to show patterns of abuse that's non-physical?
Yeah, that's a tough one. Cause I'm gonna be honest, in most divorces, I don't see a whole lot of two people who are super kind to each other. Let me tell you something, if you're in your own home or if you're outside, and I tell my clients, I don't like it to happen in front of a child, but if you're with a spouse or a significant other and they, scream, call you ugly names, get your phone out, turn your video on. Sometimes it does one of two things. It shuts them down. And if they're an abuser, and judges know this, they're gonna keep going. They're gonna keep that behavior up. So if your kids around don't do it, it's hard for children to understand that, but it's also hard for a child to watch that happen. So if you can get a kid out of the situation, and then I would videotape it. You can do that, you're entitled to do that. You're not allowed to record a conversation though. I will say that on the phone. That is illegal in Florida. If they leave you a voicemail, you got it. But otherwise you don't, and you've always got witnesses. If you have other people who see that behavior, you can, bring a witness to court.
If I made a pattern of abuse that is non-physical, sort of evidence that I've produced before is that someone comes very close to you and hits a door or kicks something in your vicinity. In other words, it poses an assault situation. You are feeling like the next thing is going to be you. They kick the dog, they throw something.
Which are all factors when you're filling out a petition for an injunction. All those things have check boxes. So if they've injured an animal, they take your phone, so you can't call someone. There's a lot of behavior that tends to indicate you are an abuser, even if it's not physical. But Carol's right. So if someone's doing that and they're putting a hole in a door, take a picture of it. You've got evidence in that.
How do you bring the video format to court? What is?
That's an IT thing, but I know I brought my computer here recently, but they're using the new, I don't even know what it's called. I'm not a techie
Are they
person.
using flash drives?
Well, the magistrate will use them, but if you're in one of the courtrooms where they have Zoom,
You can, contact the court administrator, and she can set up something in the courtroom, or as you mentioned, you could bring your own laptop or something like that
right,
to show it.
and the bailiffs know how to use it, so they can help you with that. But she's right, if you'll call administration, they will really help you with that.
Okay, we have a hand raised, from Elizabeth. If you want to unmute yourself.
Sorry about that. It took me a second to figure out how to unmute. I do have a question. When going through the dissolution process, how is it handled with financials and things when the husband's paramour moves into the marital residence and they start combining marital assets?
Well, under the mandatory disclosures, you're required to produce all statements, whether it's in your name alone or with someone else. Now, does that always happen? No, but if you don't get it through your mandatories, you can go to the court, file a motion to compel it. If the court enters an order that that person has to produce those documents, then they don't do it again, you take them back to court. Then you are looking, for an award of attorney's fees and, sanctions against that person. You can also do a request for a production of documents to get in a little deeper. Now, I will say if the paramour has her own account or his account, it'll be a little more difficult to get that information because there is a right to privacy with the financial documents in particular. So what I would suggest is if you have that scenario and you can see a spouse's bank accounts and see that there's money going to an account that they didn't disclose, send an interrogatory. Ask specifically about that account. Who does it belong to? And if you have to go to the court because they won't give you the information, you can do that. It's just called a motion to compel. You're compelling someone to give you what you asked for. And once you have that, then you can try and subpoena the records. They may make an objection if it's just the paramour's account. But there are ways to go down that path and see if you can get you a judge to give it to you. But if it's a party's account that's joint with someone else, they are supposed to produce it. Did that answer your question?
Yeah, and I just have a follow-up question with that, with what you said about the compel and the subpoenas. What if the paramour is operating multiple businesses from the marital property that are unlicensed or unbeknownst? Is there a way to subpoena those documents, the business documents as well?
And it's the paramour's business?
Yeah, that she's leasing or using space in the marital property to operate businesses.
Okay. And this is a marital home?
Correct. A jointly
take
owned property.
I take it you're not in the marital home?
I'm not, no. We have a domestic violence thing, so I'm not.
So can I ask you this? I understand what you're talking about. A paramour's in the house running a business that's potentially not legal, if you will. Why is that important to your case, the divorce case?
Well, one, because it affects our homeowners and it affects our homeowners insurance because home-based businesses aren't allowed. But
Okay.
also, I would think running something out of a jointly owned property would also mean that there would be some kind of financial right to the other person who owns the property, I would imagine.
Does she live there as well?
Yeah, she
Okay.
resides there. That's why I was just wondering more, trying to get an idea. We have a bad situation, but I was just wondering because I'm trying to kind of get feedback across the board about what that would look like, but.
Right. So I don't know if you were here in the beginning, but family law cases are very fact driven, and it sounds like you may have a lot of facts that go beyond what you just told me about. So it complicates situations, but I will tell you, you can go on sunbiz.org and you can search by this paramour's name if you don't know the businesses. If you believe in any way that maybe your spouse is involved in the establishment of the businesses, you can also search his name and see what's out there. You don't necessarily have to register with the state of Florida, but I think you could probably find out if she had a federal ID number as well. I assume it's a female. I shouldn't have
It
assumed
is, and I never considered the federal ID number, so thank you. I will definitely take that into consideration.
Yeah, no, I mean, if she's selling something, she's probably supposed to pay state taxes, sales tax. But I don't know what the scenario is. I don't know what her businesses are, but yeah, those are some ways to see if those businesses are legit.
Okay, perfect. Thank you for the advice about the subpoenas and things too.
You're welcome.
And I saw a question come in here. Thought I did.
Same
Oh,
thing.
yeah. Is there a way to show that the other parent is saying things specifically to look better for the case, but it's not consistent with their behavior?
Right. Sarah, can you give me an example of what you're talking about?
You can unmute yourself if you're comfortable with that, Sarah.
I mean, I think I know what you're saying, but just an example. She didn't unmute. So I'm gonna assume, because I see this sometimes, not so much anymore, that,
Presenting themselves to be more involved with the kids, but not following through.
okay, so I do see that a lot. So they're not really a parent until you start a legal case and all of a sudden they're all involved. I understand that. But if they're not really following through, put these things in writing. So you said you were gonna pick the kids up at 5 o'clock today. You didn't show up. Are you going to show up? The kids are asking about you. And do things like that, so you are putting it in writing. If the other person doesn't respond, of course, that's a problem, but at least you are trying to document. And it seems self-serving, and it is a little bit self-serving, but you upset people enough and they will respond, and it won't be nice, typically. So you can try that, and I didn't mention this, in family law cases, there are applications where parents can communicate, and it's recorded. And your attorneys can look at it, and the judge, at some point, if they wanted to, could look at it. So they're great applications to ask the court to allow parents to use. You would use it solely as your way to communicate. You can post expenses in there. You can post calendars for the kids' extracurricular activities. You could put in there school events that are happening, PTA things like that, doctor's appointments. This also is used for exactly what you're talking about. So, maybe you have a time sharing plan in place already and they're not exercising their time sharing. So I always tell my clients to take a calendar. I know this is old school, but I'm a paper girl. You can put it in your phone when they're supposed to have them and they don't show up. I mean, that's a pattern of behavior. You can do that. And if it's that situation, do the self-serving writings. Send them a message. I thought you were coming to the kids' baseball game. You didn't show up. That's about the best you can do with someone like that, other than what they did during your marriage or your relationship when you were together. You can always testify about that. Judges aren't stupid, and they live their own lives. So they're unbiased, but we're all human. Anything else?
Yes.
Yes.
If the party was agreed to pay like the mortgage during the pending divorce
Mm-hmm.
and they stopped paying it. And, okay, I'm on the deed, I'm not on the mortgage.
Okay.
And I was willing to negotiate the VA-backed loan for both veterans. And I was willing to talk to the VA or the lender and they refused to let me. And they're
Because you're not on the
paying and I
mortgage.
have no idea what's going on with the house and I'm living in the house. with
Do you have a
kids.
court order that they're to pay that mortgage?
In the injunction that's going to expire soon.
go back to the court.
That's what I'm trying to do.
So you don't have a family law case other than the injunction?
No, I do have the divorce too.
Okay.
I do.
So in St. Johns County in particular, and most courts do it, this is a unified court system, so you probably have the same judge for your injunction case as you do for your family law case.
Yes.
File a motion for contempt if he's not paying that, and enforcement.
I did, and he countered it with your parental alienation claims, which
Well, that has nothing to do with a mortgage
I know,
and
but
losing a
that's what
home.
they just came back at me like. And I was like, wow, I have really no restrictions on him seeing the kids. I didn't put, I
Right,
said, his attorney kept saying, only 3 hours. I said, no, extend it, you can see them more. I'm like, I need help with the appointments.
right.
Yeah,
And most
take them
parents, if they're good parents, they would like a break.
It was horrible to me.
Yeah,
Yeah, I
you
do,
know?
I need a break. It was
Right.
horrible to me.
Well, and you go to court and
Didn't do
tell the
nice things
judge
for the
that.
kids, but yeah.
You can defend yourself with that. But go file the motion and call it up for a hearing. That's something people who don't have attorneys forget about.
Okay.
You have to set hearings on these motions.
Okay.
It's great, they're filed, allegations out there, but if you don't call it up for a hearing, you're never gonna get relief on it.
Yeah, and then he is asking for 50-50, but he doesn't have a housing situation, which I understand right now is like, wouldn't he need to be able to provide rooms because our kids are teenagers? He's
Well,
asking for 50-50.
you know, he has a home, he has a place he lives.
He's staying in an Airbnb
Okay,
where the other rooms are rented out to other strangers.
oh,
Yeah,
like a community house?
yeah, so
Or you
I
have 4
guess
bedrooms
he
and
can,
4
I guess,
different
he can pay to
people?
rent out the extra rooms.
Yeah, I
if
would
he
let the
wants.
judge know about that. That's strange. Now,
Well, it's 'cause
poverty
we have
does
an
not,
injunction right now.
poverty doesn't make you a bad parent, okay? So, you know, I've had clients who, you know, have a small house and they have 2 kids and the kids are sharing a bedroom, you know, which at some point you're probably gonna need to separate those kids, you know,
They're
when they get
teens.
interested
I would
in
not want my daughter.
physical parts and things like that. What do you have? What do I have? Yeah, they probably need to be separated. But I'm not sure a court would mandate that if a parent is handling it appropriately.
I mean, he hasn't done any appointments, very little activity, and some of it is the kids, they're just like, I don't wanna do anything with you, and they do that to me too, though. They're like, I don't wanna do anything with you.
Well, now you have a duty to encourage them
And I do, I
and
say,
make them to some
I
extent.
say, he's picking you up at 4, go with him, I'm leaving, cause he'll call the police if I stay there, so I leave. Cause I'm constantly threatened that I'm gonna be arrested,
Right,
so.
Yeah. that's frustrating.
Yes,
I understand that. Your doctor's records will tell you who's taken the child to appointments to.
okay,
They almost always notate who's there with the kid.
I just wanted to add that if you're doing pleadings or if you're going before a hearing, always speak in chronological order. Don't just start in the middle of your incident unless we're talking about something truly traumatic, but otherwise try to present things in your pleadings and in your hearings in chronological order.
Tell a story,
That
and
helps
you
to-
always tell a story from
Yeah.
beginning to end.
Yeah.
It makes it much easier for the judge to
Yeah, helps the
understand it.
Unless you're in an injunction, then you tell it from the end to the beginning.
Well, yeah, that's true. That is true.
All right, well, thank you everyone so much for your participation. We will be having the next workshop on September 4th, same time, same place. If you have any questions, feel free to reach out to us on social media or communications@stjohnsclerk.com. And this is recorded, so we will be having this available. If anyone tuned in late, you might have missed something, we will blast this for everyone so you can see it.
And I have something to add too. We have talked about the platform for this. So today was really kind of a general overview. So from now on, we're gonna try and carve out specific areas of the law, specific issues, so that we can talk about those things more in depth. So I think probably when you send out a notice, will we
Yeah,
include
we'll
what
let
it's
everyone
about?
know what
Okay.
the topic is for the upcoming session.
Will it always be family law, or are we going off on like probate?
Family law.
family law.
Yep.
I'm not coming to talk about
We
that.
are talking about having some other types of workshops in the future. There's nothing solidified.
Okay.
Family law was our first focus. So,
Perfect.
if other things come up, we'll let everyone know. All right, thanks so much, everyone.